I think you very well know that there are few cases authoritatively say AG can discriminate because that is his power under the constitution. So it's up to him. Whether he wants to charge a person on lesser charge or another person on the higher charge, I think it's entirely up to him. I think in case of Datuk and then Johnson Tan on saying it's very clear on that point. And then if you look at Article 145, 3A, the Parliament also gave power to AG to choose which court he wants to prosecute an offender. This is my answer to your problem.
I think all of us are aware here that AG has absolute power to charge. I think we all already clear the position. But my issue is asking, because we are moving forward by virtue of the book that we propose in Hong Kong or some form of guidelines. I said, because this discrepancy public question. So my input is how on what basis reasons are so because of disparity of charges. I'm quite clear, I'm very certain the AG has absolute discretion to charge. In fact, AG should play the song every morning, I've got the power.
I'll try blasting that in my car.
Let me just share with you my perspective. Just share with you my perspective before I start.
See, I don't understand what you mean by you want to know reason. Why AG charge this person, don't charge this person. But when it comes to withdraw the charge, you never question. You see, under the law, AG is not there to give reason. Otherwise, if you have 1,000 cases, you expect, the law does not expect AG to give reason on every cases. Because the law presumes that when AG exercises discretion, he has done it with full honesty and integrity. That is the law.
Thank you. And not only do I have the power, I have the integrity as well. So somebody needs to write a song on that. But let me just share a quick perspective on this. And the only thing I was going to add really is this. From our perspective, and from the way we look at it, I think when you talk about cases and seeming disparities with cases, from my experience, and I've been there for a little over a year, and I think as Datuk says, that actually understates the extent of the experience because actually the one thing Chambers does is keep very, very good records. And when decisions come up, you're provided with previous decisions made, and prosecutors will research and look for previous prosecutorial decisions that were made in circumstances that are as close as possible to these. The one additional point I'd say, in addition to the 3 points I made earlier on, is this, that what appears to be similar cases frequently are not similar in the actual application of the circumstances of each case. And those differences may not be visible to people readily. The prosecution service looks at those things. There may be differences in the quality of the evidence. There may be differences in the circumstances of the offense, the offender. And to expect the attorney to have all his officers to issue virtually a declaratory judgment or a declaratory explanation on every case as to why he distinguished this or that or the other, I think may not be that productive at the end of the day. And what this is going to end up with, I think, if you take it to its logical conclusion, and you may say that I'm overstating the problem, but what I think this is going to end up with is simply move the battle line or move the debate to a different level, where it puts itself in the position of the courts, and I think the emotions still remain. Fundamentally, people who are dissatisfied will remain dissatisfied. They will still say that the courts didn't understand, if not the AG, the courts didn't understand, people didn't understand. So I'm not sure there's a solution here. And there is a point in what Datuk said, which is that there is something to be said in the fact that there is an integrity in the public institutions, and there is a balance to be weighed in this process.
I need to move on because there's one further question that I think we do need to break the session. And yes,
quickly,
yes.
I feel that the guidelines enhance public confidence, and they actually bring about less dissatisfaction because they do spell out the basis on which the decision-making process has been made, and it gives the public an insight as to how the decision has been made. And sometimes when a prosecutor's made a controversial decision, the public now understand because they've got guidelines and they see, well, that's the basis on which the decision has been made. So I think the converse is true. There's less dissatisfaction.
Okay. I promised the lady who's next to the mic that she could ask the question and we'll have a break session. Yes, ma'am.
Hello, Justine Burley, intern with LFI.